Okay, we're back in session, and from our recess, and we're on agenda item number 13, which is the presentation by our Assistant City Attorney, Don, and the title is CEQA and the EIR, Understanding the Process and the Planning Commissioner's Role and Responsibilities. Okay, Don.
Okay.
Thank you.
Thank you, Mr. Chairman, members of the Commission, staff, and public. Thank you for the opportunity to give this presentation tonight. I think a lot of the credit actually goes to Commissioner Lusk, who started peppering me with some questions about CEQA, which prompted me thinking that, you know, in all the years that I've been working with you, we see different aspects of projects, and we've had negative decks and mitigated negative decks and some EIRs, but we've never really sat down and kind of discussed it as a whole. And it is, as you can see in this slide here, a somewhat complicated process. Now, if any of you can figure out this flow chart, you can go home now. The rest of us will try in the time we have to kind of give you, an overview and some basic understanding of some things, particularly, how you as commissioners have a role in this process when you're making either a recommendation or certifying an EIR too. In order to get there, I just want to go over briefly kind of some general CEQA overview things about the act itself, the rules, the participants, when an EIR is required. And then most of our talk tonight will delve into the EIR process itself, how the impact analysis works, mitigation measures and alternatives, their purposes, responding to comments, and of course the certification, or in your case, sometimes the recommendation process, and then also distinguishing between certification of the EIR and the project approval, which are really two different things. So just going back in history to 1970, two interesting actions and two interesting political figures that you might not associate with the environment. Nixon was president at the time. The National Environmental Policy Act, NEPA, was created, which was really also kind of the model for California's Environmental Quality Act, which came into being under Governor Reagan. And just a couple years ago, CEQA celebrated its 40th anniversary. Real quick trivia quiz. What other national institution was also first appeared in 1970? Anybody know that one? Clean Water Act? No, it's something much less sophisticated. Monday Night Football.
Oh.
Okay, CEQA has two primary objectives, and I probably should flip these numbers here, but and I'm going to say this a number of times tonight, that CEQA, and particularly the EIR, is an informative document. That's really all it is. There's a public disclosure objective to CEQA, to provide information to you as the decision makers about the environmental consequences of a project, and also for the public to understand why decisions are made as well. I came across something in preparing for this tonight that I hadn't seen before. There's actually a section in the guidelines that says the EIR process will enable the public to determine the environmental and economic values of their elected and appointed officials, thus allowing them appropriate action come election day should a majority of the voters disagree. So a not very well veiled threat in the CEQA guidelines themselves that, hey, this is information, it's information for the public, and to inform them, but to inform whether you're making good or bad decisions too. Then the second part, obviously, is the probably what people focus on more is the protection part of it, that CEQA, taking the information that's part of the process, requires thresholds of significance that help guide us. And then there are also plenty of local, regional, and state agencies that are also part of the process too, because the things that we do in our city have effects that go beyond. So we're going to hear from county agencies, we'll hear from Caltrans about projects, we'll hear from air and water resource boards as part of projects too. And that's where the informational component comes in, because part of this process is to allow those agencies opportunities to comment and to share their expertise with us and for us to consider as part of the project. As you can imagine, with a statutory scheme as big as CEQA, there's its own little language and lingua. Here are just some of the acronyms that you may or should be familiar with. So when I say NO or NOE, that's Notice of Exemption, and all the way down to I'm not giving you a nod, I'm giving you a Notice of Determination, which is the last step in the process as well. So a few things to hopefully help you through the process. In terms of participants, we, certainly most of our projects are what's called the lead agency. That's the agency that is making the discretionary decision that needs this environmental information in making that decision. Sometimes, though, we may find ourselves as the responsible agency. A responsible agency is one with jurisdiction over certain aspects of a project. For example, in the upcoming high school project, obviously the high school is being proposed by the school district. So they are the lead agency. But because the high school will be partially located in our city and it is going to require annexation to the city, general plan changes, zoning changes, impact our streets, we have a role as a responsible agency in providing the school district with comments on things, because ultimately some aspects of that project will come before us as well, so we will be using that document. The other group, trustee agencies, those are bodies like Fish and Game that have resources that their charge is to protect. And so if projects affect their resources, they will comment too. And then there's also lots of agencies with jurisdiction. Again, that's going to be sometimes the county, maybe the flood control district, your air resources board. Again, they have certain tasks that they oversee, but they don't approve or deny a project. They just have resources and are basically kind of interested people. Obviously, the project applicants, when the project is a private one, not a city project, the environmental consultants that we retain to do a lot of the analysis, citizens, a key group, and various organizations, and hopefully not in our case the courts, but yes, if there's a dispute about the adequacy of EIR or dispute about the project approvals, it could go to court. CEQA only applies to projects. Now, we kind of use that term loosely because we talk about everything in here as a project, but in CEQA parlance, project has a specific meaning, and here it is from the Act itself: an activity that may cause either a direct physical change or a reasonably foreseeable indirect physical change. And it's also an action that requires some kind of agency discretionary approval. So, for example, if a homeowner is just doing something in their yard and chopping down a tree, well, that may indeed have a physical impact on the environment, but because we're not giving any approval for chopping down that tree, or they don't need one, it's not a project for CEQA purposes. So CEQA always involves some kind of agency discretionary action. I'm skipping over some of the other kind of environmental documents, the negative declaration, the mitigated negative declaration, so we can focus on an EIR. And an EIR is required when a project may have a significant effect. And typically what we do, and this is what you often see in your agenda packages when we do some of these negative decks, our staff often will go through, and there's a number of kind of check-the-box determinations on different aspects of projects, biological resources, aesthetic resources. And it asks questions, is it possible that there may be an effect? And if this identifies the possibility, a reasonable foreseeable effect, and it's a significant effect, then an EIR is required in those situations. Now, sometimes it's very easy when you're filling out those forms that if you're going to do some kind of major construction project, an EIR is going to be required because there's going to be a significant effect. There's a little irony in these slides here, this pond before and pond after slide. If you've been following in the news, the Army Corps of Engineers, which is usually a trustee agency charged with certain resources, particularly navigable streams, decided on their own without really advising anybody and without doing any environmental documentation to bulldoze 40 acres in what's called the Sepulveda Basin in the San Fernando Valley just a few weeks ago. That got everybody up in arms because they didn't consult with the public. They destroyed significant habitat. They had these trees. I mean, thousands of migratory birds were living in it, all on the guise that this was a needed kind of redevelopment of the area, partly to deal with homeless people, of all things. So they're in a lot of hot water, but I think anybody looking at these pictures could see that, yes, this was going to have a significant effect, and not doing anything at all. Obviously, they're not bound by CEQA because they're a federal agency, but they should have done something under NEPA, certainly. We often have what we call thresholds of significance for certain technical aspects, and I'm going to rely on a number of traffic things because they're and maybe Bill can jump in here, but traffic's generally sort of a little bit more black and white issue in terms of impacts here, that when a project is going to generate certain amount of traffic, we have these sort of levels of significance, starting with LOS-A, which is a nice clear open road, going down to LOS-F. And if a project adds a certain amount of traffic, it's going to cross that magic line, that threshold of significance there, and suddenly it becomes an unacceptable area or significant impact. So we're going to have to find some way to mitigate or avoid that type of impact. Okay. Here are kind of the key steps in the EIR process, breaking them down. The first thing you do is you need to establish the scope of the EIR, and the city issues something called a notice of preparation that gives notice to the various trustee, responsible, or other agencies that we're doing some project. They then submit comments on what they would like to see in the EIR being addressed that's within their jurisdiction or area of interest. We obviously invite the public to. Sometimes scoping meetings are held, and then based on all that information, staff uses it to determine, okay, what do we need to study in this EIR document? What are the key issues? What should we consider? They go off with that scope. Usually these days, sometimes city staff can do it, but because environmental reviews have become so complex, we typically farm them out now to consultants. So the consultant, working with various experts and consulting with staff, is going to prepare the draft EIR, the DEIR. When that's completed, a notice of completion is issued, and then it circulates for a period of 45 days, giving various agencies and the public the opportunity to submit comments. An optional public meeting is often part of the process. We actually had two, and again, it's optional. CEQA didn't require those 2 long evenings that we had, for example, on Conejo Creek recently. That is just part of the city's way of, again, soliciting, making it a public participation process, but it actually wasn't required under CEQA. You just need to release the document, and then people can submit their comments. Once the comments come in, the comment period closes, the city has an obligation to respond to those comments. That leads to the preparation of the final EIR, which just has a 10-day minimum release date for certain agencies before any action is taken on the project in terms of certifying the EIR. And then if the project's going to be approved, preparing a statement of facts and findings, a mitigation monitoring plan we'll talk about, and then if there are environmental impacts that are not mitigated by the mitigation measures, then you have to do the statement of overriding considerations. The precursor to any action on the actual project itself is the certification of the EIR. You cannot, when there are potential significant impacts, act on a project until you've certified the EIR. So that's how those two interrelate. Here's a list, and again, you've seen this looking through the Conejo Creek, for example, EIR, that there are a whole lot of areas that are typically covered in EIRs. Depending on the particular project, not every one of these topics has to be covered. If it's clearly not going to have any impact on certain things, typically maybe just a paragraph might be in an EIR stating that. But you're typically going to find some coverage of most of these topics in any kind of major EIR. So let's turn now to kind of the guts of the EIR itself, what we call the impact analysis. And the first thing you need to do to determine what the impacts are going to be is understanding the setting. What is the kind of condition on the ground at the moment for a project? What's what they call the baseline, because you're going to be comparing conditions as they exist now, or sometimes if it's a future project, you might have a baseline in the future as well, and you're going to compare basically the before and after condition of the environment. As part of that impact analysis, the consultants doing the analysis are going to look at the criteria of significance. They do an evaluation of the impacts and then recommend feasible mitigation measures for every impact. As I said, every impact, there has to be, in general, some kind of threshold identified. Again, some are technical. Others are a little bit more, shall we say, loosey-goosey. Like, for example, aesthetics is a good one. There is no book out there where we can say, here's the thresholds of significance. It's going to vary for every kind of project in every kind of setting. Too, a 10,000 square foot structure in the middle of an urban area is probably going to have very little aesthetic impact. If you put that up on one of our scenic ridges with a view over the ocean, you have a very different kind of circumstance. So certain criteria really depend on the environmental setting. Others are, again, more technical, like the traffic ones, like air quality, for example. Noise has certain significance, too. If you're above a certain noise threshold measured in decibels, that creates the impact that needs to be mitigated. So again, the purpose of the impact analysis is to determine, is this change going to be substantial? Are we going to go from roadways in the morning that are very light and not congested? I don't know where that is in California, but more like LOSF, or a significant impact, increased traffic there. If you go from that to that, we have a significant change. The impact analysis covers a number of different considerations too. You look at the direct impact, let's say a large housing project, well, that could increase traffic. That's a direct impact. It could increase emissions from all that traffic. But then there are also what you have to look out for, indirect impacts too of a project. If you're going to bring 1,000 new people into the city, is that going to create more demand on parks, for example? Is that going to create more demand on public services, fire, police calls, things like that? Is it going to lead to, is a new commercial project or an outlet mall going to lead to more growth-inducing types of things? Because, well, that's going to require more housing, and then there'll be traffic for all the workers getting to the job site. So there's a whole range of considerations as part of that analysis, which is, really one of the challenges. There's also, you have short-term construction impacts, you have long-term project operational impacts that you have to consider, and then you also have what's called cumulative effects too, that whereas maybe if the project in isolation is only going to do a little bit of traffic, but we can't look at the project in isolation because we have to look at everything going on around us, because we're not the only community here in Ventura County. Oxnard is approving projects. Thousand Oaks is approving projects. According to Dave, Port Hueneme doesn't approve any projects because they're all built out, so we don't have to worry about them. But we have to look at the totality of everything, and then it may be that even what normally would be a small incremental impact from one of our projects, if you took the cumulative effect of all these things, could actually cross over a threshold of significance and create a significant impact. So cumulative impacts also have to be considered as part of the EIR. Okay. Now getting to some of the nitty-gritty of the, what is the analysis based on, and this applies both to our own analysis and the analysis by third parties or the public or outside agencies. The guidelines are very clear that there's this concept called substantial evidence, and I'll be returning to that more. But substantial evidence are facts. They're reasonable assumptions based on facts, and they're expert opinions based on facts. Evidence does not include just simple argument or speculation. Gee, I think that's going to happen, or opinions or wrong information, and certainly not NIMBY. Well, I just don't like it. It's too close to me. Well, that's none of the above. That's not really evidence of anything at all. I think one of the challenges for really you as a reviewing body, and certainly city staff, and in reviewing some of these reports is, well, how much detail? Let me throw out a question. There's actually, in the regulations themselves, page estimates of an EIR. Anybody want to venture a guess what a normal project page limit could be considered to be? Brian?
300.
Too high. It's actually 150 for a normal. If it's a complex project, I think that's what Brian was thinking about, that's 300. But actually today, I've rarely seen an EIR that's under 300 pages. So that's kind of gone by the wayside. So it's been a real struggle. I think that it's certainly been an issue, and it's been discussed a lot. Well, how far do we have to go with these things? And that's what's challenging. But what the rules say is that it need not be exhaustive. It does not have to include every conceivable study out there, because the process would never end. Obviously, the level is going to depend on the type of the project. If it's a construction project, it will have greater requirements than when we do, for example, a general plan amendment, where things can be less specific, less analysis. A couple of hints just as the test. Is there sufficient information analysis to sort of understand the basics? And I think that's the key. Is there enough that we can understand? Can we make the connection between the analysis, the impact, and your decision with things? Is there kind of that evidentiary trail here? And other things to look at in the detail in terms of using certain methodologies and standards that are acceptable too. And again, that's something that's generally done at the staff level, that we will make sure that is part of the there's a step that I left out called the administrative draft EIR, that before it gets released to the public, staff does review it to try to ensure that it is meeting these thresholds in terms of the analysis. Once impacts are identified, then it's up to the consultants to suggest different mitigation measures to either avoid, to minimize, to reduce them over time, or to compensate for certain impacts. For some impacts, for example, traffic's one, we can use financial compensation, such as fee programs too, that are designed to provide funding for us to, on a citywide basis, mitigate fee impacts, such as upgrades to our wastewater treatment plant and things like that. Those also constitute acceptable mitigation measures for certain aspects of a project. There are certain legal requirements that are tied into the mitigation measures. There has to be the nexus. That's not Commissioner Boyce's car. That is the legal connection that has to be made between the mitigation measure and the impact of the project. There has to be a connection between the two. There has to be a proportionality. If you have a slight impact, you can't really put on the developer, well, fix everything. Build us a new wastewater treatment plant just because you're building 50 new homes. That's not proportional to their impact. And obviously feasibility is one too. Is it something that within, commercially reasonable means can something be achieved here? So, for example, if 100 new homes are being constructed, maybe we need a small little pocket park or something like that. Maybe there's going to be enough traffic that a stoplight is warranted. There's a nexus there between, the project's impacts and the mitigation measure. Constructing a new art museum, while it might be nice and maybe there's more people in the community and maybe the homes are really ugly and we need some aesthetic enhancement to our lives, there's really not that legal nexus to require somebody who's developing 100 homes to give us a new art museum in the city, much as we might like to have one. Okay. Again, I want to stress that mitigation measures do need to be feasible. Oftentimes there's debates about that because, especially today with technology, yes, there are a lot of things we can do, but is it, considering both the economic, the social, the technical aspects, can it really work? For example, a feasible mitigation measure might be the reduction in vehicle trips by a small percentage, 10%. That's probably doable. It's not going to cost that much. Whereas a measure saying, well, we just don't want any more greenhouse gases in our city. We're not quite at that technology. We don't have those kind of Jetson cars out there yet that will carry us around without causing any greenhouse gas emissions. Although I do hope they develop those soon. I like this. Okay. And then finally, the last component that's not actually technically part of a draft EIR. It comes at the end of a project, but we take all the mitigation measures that are recommended for a project based on all the impacts, and they're compiled into what's called the Mitigation Monitoring and Reporting Program. These become part of conditions of approval. If a project's approved, they become enforceable conditions so that the project can't proceed or certain aspects until these mitigation measures are done. They're a little bit like your conditions of approval. When you're, for example, approving a CUP or one of our other plan development permits, we have all those conditions. Some of those are sort of, in a small way, kind of mitigation measures, too. So that's similar to what the program is in an EIR. Okay. Another aspect of the EIR process, it's also often controversial. It's intended to, again, suggest alternative ways of mitigating project impacts is what's called the project alternatives. And these are required. CEQA does require consideration of a reasonable range of alternatives. Again, that's going to vary depending on the project, but you at least have to look at 2 or 3 different ways to do a project potentially. And then there's what's called the mandatory alternatives. There's a no project alternative, meaning it doesn't happen. The purpose of that is so you could actually kind of look at the cumulative effects. Well, what's going to happen if something isn't built? Sometimes there can be negative consequences, actually, if a project isn't built, or you can see what's going to happen regardless of whether the project's going to happen. And then there's a requirement to identify an environmentally superior alternative measure. Now, you are not required to approve that. That just is, again, part of the CEQA process to show, well, here are all these different alternatives. Which one really is in terms of the environment, the best one? Yes?
And who comes up with those alternatives? Is it the consultant?
It's done in consultation between the applicant and city staff and the consultant, typically.
And is it that's usually written in the EIR, the alternative?
It's usually part of the scoping process to consider it. Usually you'll go to the applicant and say, well, okay, give us some suggested alternatives here, because again, they have knowledge, well, what's feasible for them? What meets an applicant's going to state, well, here's our project objectives. we want to achieve this. We're looking to develop a major commercial center of 100,000 square feet in the city that's capable of doing this and, meeting these needs. So they have their objectives. So it's kind of a collaborative thing. Sometimes there's a dispute about it. Sometimes the consultants will select alternatives that the applicants don't like. So there's no kind of set formula. Dennis might have more experience. I know I've been on the other side sometimes too. I wasn't happy with some of the alternatives selected too for various reasons, but that you don't always get a say in that if you're the applicant. Yes, Commissioner Hammonds?
Recommending certification in the EIR is simply to make sure that the mandatory alternatives are there rather than making any value judgment on those alternatives?
Yes, yeah, that's
this
just
point.
Yeah, just a required part of the process. Again, for disclosure, to prompt your thinking about them. But I do want to make clear that, for example, often the environmentally superior alternative is usually not the project that's selected, because it's usually some kind of reduced alternative, because it's going to have less impacts there. It just shows you, well, really, of the different alternatives, this one is the most superior to the project here. But again, oftentimes that's not the project that people want. They're not going to, develop it, so there's kind of no point in doing it. It's an informational thing. But then sometimes, if an applicant is faced with a decision between, the decision makers want an alternative or not, then, well, they either get their project or they don't. So maybe they need to consider the alternative project, because that's the one that the council likes for various reasons, both what it accomplishes, but also for the purposes of reducing impacts.
So it may or may not be distributed in the final document, these alternatives?
No, these alternatives are always in the final EIR and the draft EIR too. Now the mitigation monitoring program is not always compiled into the draft EIR, even though all the mitigation measures are usually there.
Okay. Thank you.
Okay. Just kind of backing up again about this project alternatives, there are criteria for selecting them. Major one is the feasibility. Two is, does it really obtain most of the basic objectives of a project? And then again, the focus of it is to see and to show, are there ways of lessening significant impacts? So I just came up with a hypothetical here, found two images that kind of look the same. And let's say a city wants to create a new music hall. Okay, and you have the one on the left here, which is really big, and it's going to, seat 7,500 people, but it's large and maybe might block a view corridor or something like that. So you look at, well, what's a reduced scaled one? Well, here's a 5,000 seat symphony hall that would, be economically viable, because we need to have at least 5,000 patrons to support the symphony, but this doesn't have the same aesthetic impact. It's smaller. So that's what it really prompts the discussion for the decision makers. Okay, the public comment part of it, which you've already had some recent experience in, but there are a number of purposes for that review. Obviously, not just the public, but other agencies that we share a document with. We're looking for their expertise and comments on things. It's a reality check and accuracy check. These are very complicated studies. Consultants do their best to take information from a lot of different sources, but they make mistakes. And so that's part of this kind of vetting process. Sometimes things get omitted. So the comments help us uncover, completely forgot that aspect, or missed something there. Public concerns come out very clearly as part of that process as well. And then sometimes members of the public or other agencies often propose their own proposals or alternatives that maybe hadn't been considered, that maybe an agency likes. So these are just some of the reasons for the comments. In terms of a legal duty, we receive the comments, and then we have an obligation to provide written responses to all the comments, and our duty is to provide a good faith reasoned analysis of the comments. If we disagree with the comments, then we need to state the grounds for it. Conclusory responses are not acceptable. You can't just say, well, too bad, so sad, it's going to affect things. No, you have to explain why that is. But at the same time, we're not, as I said before, required to conduct every test about things, to do every conceivable kind of research. There's kind of a reasonableness to the process here. We want to be thorough in our responses because, again, this is a public disclosure document. Every comment does not require a response, though, only the ones that deal with significant environmental effects. And I think, as you realize, sometimes people confuse the project process and the environmental process and just say things about just general, gee, I don't like the color of this, or, I hate this. Well, okay, did that have an environmental effect? So usually what you'll see in the responses to comments, comment noted and will be forwarded to the decision maker. It really doesn't have much relevance to environmental concerns. And again, a general response only requires a general kind of comment. Now that this is a significant area here, and let's pause here for a minute. Disagreement over information. It's a little bit like the bad ethnic jokes out there. You put two of any kind of ethnicity together and you get three different opinions. Well, that's kind of how things are with comments too, that you put a project out there and the public's going to have varying views about that, and often there's disagreement with the analysis that is provided in the EIR. You do have discretion in weighing this evidence. It's certainly within the city decision makers' discretion to accept the conclusions of the experts who prepared the EIR, but you have to make sure that there is some substantial evidence. You just can't say, well, that's our guy, and I don't like their guy. Part of this is to see, do the assumptions, do the methodologies that the city's using in this document, do they make sense? Do they appear to be reasonable? Just because they're differing views, though, I do want to make clear that doesn't make an EIR inadequate. Okay? You're often going to get people come in with their own experts that will say something completely contrary. Well, that may be. And at the end of the day, maybe you agree with that outside expert, but you don't have to. If you look at yours and feel comfortable with the analysis, that's okay. That's all part of it, and that's going to go kind of into the finding process too, that will make findings about certain things, showing why we chose this theory or impact versus something else. Again, substantial evidence is always the test, and what the EIR really needs to do when there's disagreement, particularly significant disagreement based on evidence on both sides, is to summarize those points, because it's an informational document. Okay, well, this person said X, Y, and Z. Here's their analysis of it. If we've done that, but we disagree in the end, that's compliance with CEQA. Okay. Substantial evidence, this is a term of art. It's defined in the regulations. It's enough relevant evidence and reasonable inferences from the information that a fair argument can be made to support a conclusion, even if there might be other conclusions reached. Okay, so evidence can point in two different ways. As long as there's a fair argument that there's some reasonableness about how you reach that conclusion, that's all CEQA requires. Okay? We don't have to double up or triple the studies to outstudy them. If they submit or somebody submits 1,000 pages, it's not always the weightiness of things. It's really the analysis, the disclosure. Have you disclosed something? Hopefully this will make you feel a little bit better. It's not a process of perfection, and this is actually lifted right out of cases. The courts don't look for perfection. They realize that it's a process, and sometimes it could be a flawed process. It's a question of adequacy, of general completeness, and of good faith effort. That if the document shows that you listened to comments, that you did your best to respond to comments and put the issue out there, that's all that's required. people might disagree about the conclusions reached. Courts are not going to second guess you. They have, and our chairman's probably familiar with this, judicial deference to things. They are going to defer to you. The courts are not sitting up here hearing these things. They don't want to be the sixth person up on our dais up here overturning you on, things. What they look for is what's in the record, what were these things considered, is there sufficient evidence that led you to either find an impact and mitigate it in a certain way, or find that there wasn't a significant impact. Okay. The responses to comments, once they're completed, do not actually require a separate review period. Sometimes the comments, actually oftentimes, the comments are going to result in some text changes because, again, the first draft is a draft. It's never perfect. There's going to be changes made. If the comments on the whole result in a lot of new information, maybe even changes to the project, or findings of new impacts, then there's a requirement for what's called recirculation. That means that the public, because this information is so new, you have to recirculate for a certain period of time the document. You don't always have to do the entire EIR. If it's just, let's say, a flaw in the traffic analysis, then you would recirculate only the traffic study. You don't need to recirculate the parts containing the biological resources, the aesthetic impacts, the economic impacts, the public service impacts, only the portions affected. So typically it's only portions that get recirculated if there's a need for it. And then the only rule on the time period for the responses to comments is 10 days before you take any action. Oftentimes agencies will give longer, but the minimum is 10 days that you provide the responses to comments, and you can't take any action on certification for at least 10 days. Fairly short. So we're down to the last part of the process now, the final decisions, the certification. Okay? As I said before approving a project, you have to do what's called certification of the EIR. Okay? And they're two very different concepts. The certification process requires three things here. First, was the document reviewed and considered by the body? Does it reflect the decision maker's independent judgment and analysis, and has it been completed in compliance with CEQA? Now, those are pretty broad principles, so let me try as best I can to define it, but actually the regs don't provide a lot of detail in it. This one they do. Was it reviewed and considered by you? Well, I can tell you what you can't do. You can't turn to Dave or to Steve Mitchell or to myself and say, hey, I'm kind of busy this week. Would you guys review this EIR and give me the thumbs up on it? No, you actually have to take some ownership of it. But you can rely on us, on staff reports, on summaries of our testimony, and certainly you don't have to sign any statement under penalty of perjury that, yes, I have read and reviewed 1,000 pages of this EIR, the 5 traffic appendices, all 8,000 pages of those, the geotechnical report from A to Z. You don't have to do that. It's really a little bit more perfunctory than that. It's really just a finding that, no, we did consider this general. It's been before us. We've reviewed it. That's all required. The independent judgment, it's really just a statement, quite frankly, in the certification that, yes, this reflects our independent judgment. Really, it kind of ties into this other one, was it considered by you? If you've done the consideration, then if you're taking action on it, presumably it reflects your independent judgment. There's no particular criteria for this step. And then the compliance with CEQA 1 is very broad, somewhat amorphous. Here's a guideline on it. Has the EIR been prepared with a sufficient degree of analysis to provide the decision makers with information that enables them to make a decision which intelligently takes account of the environmental consequences? Pretty generalized, but that's what adequacy means. There's a a court put it another way, which I kind of like. Does the EIR discuss the project in sufficient detail to enable the public to discern the analytical route traveled from evidence to action? How about that one? Is there enough there? How do we get from this evidence to the action we've taken? I kind of like that one. But they're pretty generalized, okay? There's no massive checklist for you to say, oh, yes, it's all fully adequate there. Now, again, there are obviously challenges to adequacies of a document, and just pointing out what some are so that you're aware of it. They usually fall into two categories. There's going to be the procedural deficiencies. That's not your issue. Hopefully staff is going to ensure that that doesn't happen, but we want to make sure that we provide proper comment periods, that when it's 45 days, we didn't cut it short at 30. That could result in a challenge because we didn't technically comply. Oftentimes there's arguments raised about recirculation. Again, that was the issue. If there's a lot of new information that comes out after the draft environmental impact report was circulated, sometimes you have to go back and recirculate. And if you don't, you can be dinged on that. So oftentimes, out of abundance of caution and to moot that argument, if there's a fair amount, perhaps not technically the amount required to really recirculate, we will recommend that the city do that. Anyhow, just to eliminate that potential claim here, because it really just slows down the process a little bit. And usually the applicants are good with that because we'd rather recirculate for 30 days than litigate for 30 years in our California court system now. Then the technical deficiencies, those they can certainly happen. Again, it's really, you're going to have to rely hopefully on staff and consultants and the applicant also in things to ensure general compliance. But there are a lot of things that can go wrong in the process. Sometimes the wrong baseline condition is used, maybe a wrong threshold of significance, perhaps improper analysis. Sometimes, or more often than not, it's usually things like a cursory analysis that somehow agencies get lazy. They kind of, gloss over something when something's been pointed. That's why it's always good just to, you have to go back, try to deal with it, provide some kind of explanation as to why you might be disagreeing with something. If you do that, you're good. Where a court will ding you is if you just kind of gloss it over. Somebody points out till they're blue in the face that you've admitted this and you just ignore it. And if a court agrees with them, then you might have to go back and fix that. So what are your options going to be at the end of the day when you're making your recommendation? Okay, you can recommend changes to the EIR. That's going to be certainly within your discretion, or that certainly the council review it further certain areas if you're concerned about adequacy based on the comments and your own review of it. So as part of that, one of your options may be, okay, well, what's the topic, what's the analysis, what's the response that you're concerned with? So when we come back in and ask for your recommendation, if you have certain areas, we'll be asking you to kind of give some detail. If there are things that you're either not satisfied with or maybe question, and maybe you want the council to look at, those further. Okay. What we probably won't do in a recommendation process is go back and do it because you're only recommending. So we will just take your concerns and pass them on here to the city council for things. But certainly if there are areas, then we're going to welcome your input about what you may or may not like or may think requires further review. Yes, Joe?
Is it an option for us to ask the consultant to make some changes or identify some things that we see, or do we simply point those out when we make a recommendation to the city council?
I think here, and again, I don't want to get ahead of myself, but since you're only making the recommendation, if you were going to be doing the actual certification, oftentimes planning commissions do certify because the council only gets involved if there's an appeal and it goes up to them. So you could, in effect, if you were the decision-making body, then we would probably do that. We would say if you have certain concerns, then you would direct the consultant to make certain changes. Here, because you're only advisory and recommending, that we'll probably just incorporate what those concerns were that whether it's an individual one or if you collectively agree on certain concerns. Well, 3 of the 5 commissioners felt that this analysis could be more specific or felt that it admitted this. I think those are the kinds of things that we'll be, looking for and pass that information on to the city council. And they, in turn, if they agree with that, then they can tell the consultant, hey, go back, do this. We agree. That's a good point. That's admitted here. Commissioner Lawson?
I'm assuming it's okay with our recommendation to council, that we include level of significance. Just if we are concerned about level of significance, we can include those discussion points?
Yeah, absolutely. If maybe there was one issue that they felt was the impact was not significant and you have a different view, then you're free to share that.
We don't have to go through level 5, level 6, or specifically,
No, just in generalities.
Okay.
Yeah, depending on what it is. Mm-hmm. Obviously, on the other hand, if you feel that the process is good, that it works, that the EIR is adequate, then you can recommend it, as is, too. That's going to be one of the options as well. Okay. One of the things to keep in mind, yes.
I have one more question. I think if I remember right, either the first or second public hearing we had on this, or the second meeting of the same public hearing, somebody made comments about the inadequacy of the following the rules and the guidelines. Is that something that we should defer the judgment on to staff, or is that something that we need to look into?
I guess when we get to the specifics, what exactly that is to look at. Some of them, the consultants or staff can, briefly respond to those if it's a, kind of consistency with guideline type of thing. Again, the real challenge is just in dealing with taking the analytical parts of the impact analysis and really kind of grappling with that sometime. But again, hopefully tried to make it clear that really the role is to look at the evidence there. Can you follow the kind of the chain of thought, really, of how that evidence was used, looking at the environmental setting, the impacts, the changes, and does the mitigation really address it or not? Could something else do? I mean, there's a whole range within all those points. There are a lot of different things that you might have thoughts on, and that's what we'll be looking for you for input on. Okay. Just getting back to the certification or recommending certification versus project approval, because people just conflate the two, and they're really, I hope I've tried to make it clear as many ways as I can, they're very different concepts. Certification of an EIR is really saying, hey, this disclosure document's done its job. It showed us all these potential environmental impacts out there. By certifying it, you're not saying you like the project or that you're going to approve it. You're saying, hey, it's been disclosed. We've seen what the impacts are. We know if we take this action, this is what's going to happen. So certification is a prerequisite to taking action on a project. You do have a duty the city has a duty to prepare, complete, and to certify an EIR. So there's not really a question of we can't certify. Okay? If you have issues about the adequacy, we can send it back, and that could be a direction. But if you don't want a project, the proper action is not to certify and dissemble about certifying the EIR. No, at some point you have a duty to complete that because the applicant has requested it, they paid for it, we have a duty to prepare it to the highest standards we can and to certify it. The approval of the project's a different matter. Okay? It's not a pretext for denying a project. Okay? But projects can be denied based on a number of things. If there are significant unmitigated environmental impacts, as shown in the EIR, that could be a ground for denying a project. There are obviously other laws, too, that allow us to deny projects because they are discretionary projects by nature. They're vested with you to approve. You don't need an EIR. You can deny CUPs for various discretionary things, consistency with general plan, consistency with zoning, failure to meet development standards. All those things are all, the legal reasons for denying projects. The one that really CEQA ties into is this top one here about significant unmitigated effects. If a project's really going to cause considerable damage, that could be one of the bases a body could use to deny a project. Okay. The other option, obviously, is project approval. And when you do approve a project where an EIR has been prepared and there's significant impacts, you need to make certain findings. And if there are impacts that can't be mitigated, you have to do the statement of overriding considerations. Findings are a little bit, they're sort of like the findings you do when you're approving certain things, but here these are findings about the impacts of the particular project, what changed, what steps we did or couldn't do to avoid that impact. And there's typically this kind of three-stage analysis where you list what the impact is, you make the finding as to what you did about it and the facts that support your action. Those are required when approving a project for each significant environmental impact. If you have impacts that cannot be mitigated, either to a substantial level or avoided, then you have to do the statement of overriding considerations, and it's a written statement that's part of the project approval process, specifying the reasons that support your action based on the EIR and the record. And then these reasons can be things like legal, economic, technical benefits for a project. Again, as I said at the beginning, let's take a hypothetical, maybe a new office park project or something that's going on, an empty area or a wetland or something like that. Obviously, there's some environmental impact because of the condition of the environment. Anytime you're developing on open space, you're going to have some kind of impact. So how do you justify it? What benefits does this project bring in terms of, does it have jobs? Is it going to, strengthen our economy? Do different things. Those are the findings you have to make to show why you're approving something that has environmental impacts. If you can't make those findings, then you're obviously not approving the project, and you have to deny, because you have to be able to make those findings in order to approve a project that has significant impacts. Okay? When a project is finally approved, when there's been a CEQA document, particularly an EIR, then you issue a notice of determination. That gets filed, and that's what triggers the 30-day period to challenge something in court under CEQA. But the notice of determination doesn't actually get issued until you approve a project. So it's tied to the project approval, not the certification. And sometimes, like we're doing with Conejo Creek, we're actually doing certification separately. So there'll be a certification, presumably, and then later at some date a action on the project. And so there won't be any NOD or notice of determination filed at the time of the certification action, because the project's going to come later. Okay, so that's really the last step in the process there. So it's been convoluted. It's been, but I hope, this provides a little bit of background and discussion, but certainly want to entertain any questions. And again, as we deal with documents in the coming months and years, please at any time, ask us things. We can always do a short workshop before a meeting, something if that helps you, with some of these concepts here, because it's challenging. These documents are complex, they're technical. We have to a certain degree rely on the consultants, but engage the public and kind of blend that all together, and that's not an easy task. But I think what's important for the public, I think what they fail to understand, and maybe we should do this again for the public, is really helping them understand that CEQA, is to do exactly what a lot of the members of the public are doing, providing information, discussing what the impacts are, so that there's really informed decision-making going on, not things just happening in the dark or just decisions being made without really thinking about what may happen.
Thanks very much, Don. I thought that was real helpful. Does anybody have any questions for Don?
I too would like to thank you. You did more than I anticipated when I asked. Really a good job. Thank you very much.
I
My
agree.
pleasure.
I appreciate the time you took. It really has been helpful to us all.
Good.
Thank you.
Yeah, I thought it was real helpful too, and I thought what's interesting, I didn't realize that the public hearing aspect isn't a requirement.
Yeah.
but
Yeah.
Yeah.
I
people don't
personally
understand that.
find that extremely valuable, because in reading those, 500-page reports at the public hearing, things get pointed out that I missed, or, makes me go back and take a second look on comments people make. So I really benefit and appreciate the public comments. I'm glad we do that in this city, yeah. Public hearing.
I'm kind of glad to find out the city council is the one that's really certifying.
Well,
Yeah, Wayne?
And speaking of being off the hook, Don, I think we should nominate you to make a presentation at one of the League of California Cities events. Good job.
I'll consider that. Thank you. Obviously, you have the handout you can take back, but we also got from a consulting firm that I work with in some other cities. They have this nice little short CEQA book,
yeah.
too, that has some nice concepts. It's kind of distilled down, and that may be helpful as well, too. And there's lots of information out there. There's, as pointed out in my at the end of my presentation, too, certainly the governor's office, the OPR that does this has stuff, and also the series site, too, with the guidelines and all that. There's plenty of information out there, but hopefully some of these will at least get you speaking the lingo a little bit and help you kind of laser in on some of the issues that come before you. It's a daunting thing, so I'm glad at the staff level that I don't have to make that call either. We just process the best we can.
Are we going to take the test now or next week?
Next week will be fine. We'll give you a little bit more study time. Actually, the big test will come when we go through the process. And
Yeah, thank you very much, Don.
okay,
Appreciate
my
it.
pleasure.